Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hi, everyone, and welcome to our Curious Amalgam. We're very excited today to have Veronica Roberts with us to tell us what's going on currently with the CMA. There's been a lot of developments recently, a large number of recent CMA announcements and changes in process. And so we're very excited to have her with us to give us more background and bring us up to speed.
It's very good to be here. Hello.
Thank you very much, Blair. This is Matthew Hall. Our guest, as Blair mentioned, is Veronica Roberts. She's a partner at law firm Herbert Smith Freehills, based in London. She leads the firm's UK competition, regulation, and trade practice. Thanks again, Veronica, for joining the show. As Blair mentioned, there's been a rather amazing flurry of recent activity from the UK government and the CMA, the Competition and Markets Authority, which is the main UK antitrust, digital markets, merger control, and consumer law regulator. Outside the antitrust advisory world and companies that encountered it, the CMA, I think it's fair to say, was relatively unknown until April 2023, when the CMA blocked Microsoft's proposed acquisition of Activision Blizzard, gave rise to a large amount of controversy and comments from the government and the company itself, ultimately cleared in a different form. Episode 239 of our Curious Amalgam covered that saga. Moving forward a bit, we had a new Labour government elected in the UK in July 2024 on what it calls a growth agenda. And since then, the pace of announcements in this area has been quite relentless. The CMA chair was removed in January 2025. A draft strategic steer by the government to the CMA was published in February 2025. And as we record this episode, the most recent activity was the March 2025 publication by the government of a general policy paper titled New Approach to Ensure Regulators and Regulation Support Growth. That includes a specific section on competition and the CMA. And also, amongst other developments, the CMA now has its new powers under the DMCCA, the Digital Markets Competition and Consumers Act. So, Veronica, as we mentioned, there's a lot going on. What do you think has been the main catalyst for all of these Labour government and CMA announcements that we are seeing?
So I think, Matthew, the main catalyst will be the feedback that the CMA and the government was getting from investors, who were finding it increasingly hard to predict how their transactions or investments would be dealt with under the regime. So I think that's probably the main catalyst. The CMA, to be fair, had started already to engage a lot more with investors. So they'd set up, even before we saw the departure of Marcus Bockering, they'd set up the Growth and Investment Council and invited the British Venture Capital Association, the Chamber of Commerce, UK Finance, other important trade associations to go in more regularly to the CMA and talk to them about how investors were finding the processes and how they could be improved. But as you said, that was then overtaken by a lot of government activity.
Do you think that the resignation or the forced resignation of the chair was really about policy and what the CMA was doing, or was it really just kind of an easy target and a message to the worldwide investment community?
So for me, I interpreted it as a really a message to the investment community as a whole. I mean, it was really interesting. If a few months ago you would be speaking with banks and very large investment firms about merger control regimes worldwide, and they would be saying that the UK CMA was steadily making its way to the top of the list of regimes where it was really difficult to predict how they were going to fare. So I think it was seen as a really important message to that community.
That's really interesting and quite helpful. I did want to ask about a more recent development. there's been a lot of discussion around the mergers charter and how the CMA is going to consult on remedies moving forward. These initiatives do suggest a broader effort to make the UK's merger control regime more efficient, proportionate, and predictable, as we've heard. How do you think those will play out? Do you think they'll have that intended effect?
Yes, I think it's a really interesting question. The CMA has also been recently inviting evidence on remedies, so how structural remedies are working in practice and how behavioural remedies, the very few that have actually been agreed, have been working in practice, all with a view to potentially changing their approach to remedies. And it is quite interesting looking at recent cases. So you've got the Vodafone 3 case that the CMA cleared conditionally, and they were subject to what we would class as behavioural remedies, so a control on consumer pricing and a commitment to invest a huge amount of money in the UK's telecom infrastructure. So it was really interesting to see a shift in that case. Does that mean we're all going to be able to get our cases cleared with behavioural remedies? No, I think it's very much a case of watch this space. I think the Vodafone 3 case is a bit different. There was obviously infrastructure in need of investment, also a separate regulator, Ofcom, that was around to help with supervision of that pricing remedy, because the CMA, like many regulators, has always said it's reluctant to impose remedies that it then has to spend a lot of time policing. So the fact that Ofcom as a sector-specific regulator was around to do that really helped. But then I think we have seen other cases where more behavioural remedies are being proposed. So it's definitely a start of a new trend.
That is quite interesting. I mean, I think traditionally we've all been a little bit hesitant to bring any type of behavioural solution to the CMA given past practice. There's obviously a lot going on.
I do think that one issue with the UK merger control rules is the fact that the jurisdiction of the CMA is quite vaguely defined. As you know, in many other merger control regimes, there's quite a bright line test about the percentage of shareholding that you acquire or the level of control that you acquire, and then the regime is triggered. We have this more nebulous share of supply test. And in fact, as Matthew said earlier this week, the government produced a paper where I think the government has realised that they may need to look at changing the legislation, because after all, the CMA is also operating within its legislative restraints. And so the government now say that they're looking at the share of supply test, and they are also looking at material influence, which is the control trigger for our regime to apply in principle. And of course, everybody knows that material influence exists usually at 25% plus, but there are a few cases where material influence has been found below 25%. And, you know, we all know what principles mean that you could find material influence at a lower level, but the CMA really has not set out or had the opportunity to set out very clear guidance, because it's obviously quite case specific. And then we have had a few cases in the AI space, the AI partnerships recently over the last few months, where there have been partnerships or minority acquisitions by tech companies into AI companies. And the CMA has spent a lot of time looking at those cases. And in most of those cases, they found after quite a lengthy investigation that they don't have jurisdiction. And that I know, and we hear on the grapevine, is something that the government did find to be unacceptable, that it would take so long for companies to know whether they were even within the CMA's jurisdiction.
As you say, Veronica, the CMA has very wide jurisdiction, and even Sarah Cardell, the CEO, has commented that it's an unusually broad jurisdiction by international standards. Looking at that issue and the recent changes, what are your views on, firstly, the number of deals that the CMA is going to call in, like the tech investments that you mentioned for review? Because remember, listeners, this is a voluntary jurisdiction, in quotes, so you don't have to file. And also, secondly, Veronica, on the number of global deals that the CMA will review at the top table, if you like?
Yeah. So on how many cases is the CMA going to call in, whether that's of its own volition because the parties have not approached the CMA at all, or perhaps the parties have done a short briefing paper, which is possible, just to get some views or confirmation that the CMA does not wish to investigate. I think going forward, given everything that's happened over recent weeks and the focus on proportionality and process, I think that the CMA is going to think very carefully before it brings cases in for investigation. Now, that's not to say it won't ask for information. I think we're going to continue to see those requests for information once it's seen a transaction in the press. And we all know what the standard questions are. Why have you not? Are you planning to notify this? And they ask questions to determine whether or not, in principle, they would have jurisdiction. And probably the most important question they ask is the share of supply test met, and what is the combined share of supply after the transaction? Often that type of information is quite difficult for the CMA to ascertain from the general press. So I think we're still going to see those inquiries, and companies need to be ready for those. But I think we're going to see the CMA thinking a lot more carefully now before they say that they actually wish to investigate a transaction. And then on your second question, Matthew, which was about their profiling global deals. Now, this is a really interesting one because post-Brexit, it was very much a question of seeing the CMA rise from out of its European competition network, where they had to liaise with other European national state competition authorities. And the biggest cases ended up going to Brussels under the merger regulation. Suddenly they rose out of that and became an independent competition authority on the world stage and started reviewing some of these very large global deals alongside the European Commission. And of course, Microsoft Activision is a really good example of that. So suddenly they had a place at the global deals table. But now I think we're going to see a little bit of a U-turn away from that. Part of what the government has also been messaging during the course of this week is that they want the CMA's decisions to be coherent where other international merger control authorities are also looking at the same transaction. Now, that's not quite a direction to step into line, but for me, that was quite a strong message that the government's not keen on seeing just the CMA stick its head above the parapet in the same way as we saw with Microsoft Activision at the outset.
It sounds very much like that message, and I think your comment about requests for information carrying on, but the CMA then thinking a lot more carefully about whether to actually start a phase one investigation, even if it can do, is very interesting in practice. Before we move on to competition or antitrust enforcement more generally, Veronica, we've mentioned Microsoft Activision, this now notorious case, first originally blocked in April 2023 by the CMA before being cleared in a different form later that year. Worldwide deal looked at in the US, EU, and numerous other jurisdictions, of course. Do you think that that is probably, if you like, the high watermark of CMA intervention in mergers? It has a lot of the characteristics of what the government is now trying to push the CMA somewhat to avoid now.
I think that's right. I think that the CMA will try to work closely with other international competition authorities if it is reviewing one of these, or when it is reviewing, because it will do one of the huge global deals next time. I do think, though, that we're going to end up seeing the CMA focus more on what it used to focus on, the really UK-centric transactions as a result. Now, of course, it'd be interesting to see what they do with our merger control test. There's no suggestion at the moment that it's going to be changed into a mandatory filing. So that does give the CMA some flexibility to step away from investigation of the global deals where they don't think that their duty to refer is caught, because we have to remember they do still have this statutory duty to refer a transaction to more in-depth investigation if they believe that there could be a competition effect in the UK. So those global deals will still be reviewed, but I think we're going to start seeing a bit more of a UK-centric approach in terms of transactions.
Before we turn to competition enforcement, Veronica, based on kind of all of that we've just covered, for clients that, you're counseling that may be below that 25% material influence standard, just given the recent shift after Microsoft Activision, how are you counseling clients to think about going in with a briefing paper under those circumstances?
Yeah, so that's a really good question. And I've seen various comments around the city in recent days saying, this is the time to go in and do your transaction and not mention it to the CMA. I think that the briefing paper process can still be really quite helpful when you're dealing with a transaction that you know is going to make it into the financial news or the trade press. And at first blush, you know that the CMA will look at it and think, well, hold on, does that have an impact on competition on consumers in some way? And as I mentioned earlier, that it's not always possible to tell really when you see the write-up and certainly the corporate spins on what a transaction actually means. So I think in those cases where you know that the CMA might read about a transaction and wonder whether we should be looking at it, I think there still is scope for going in first proactively with the briefing paper. As you know, they limit it to 5 pages. The point is you don't need to give them the kitchen sink. You are just describing the transaction to them and explaining why they don't need to look at it. I think that we and many others will continue to use that briefing paper approach. But it is, of course, open to you with the transaction to not go in at all. And they are able to pick it up to a certain time after a transaction is made public. And if they miss that timeline, they will not be able to review. So I'm sure that is something that some companies will also look at quite closely as well. I think one other point that we haven't touched on that is also relevant is the judicial oversight of CMA merger decisions. So we have got the Competition Appeal Tribunal, and hasn't really made the news so much, but they did look at a merger prohibition case, the Spreadex Sporting Index merger prohibition, and issued an order a couple of weeks ago that basically said to the CMA, and the CMA had actually said to the Competition Appeal Tribunal on review that they felt that they could have done a better job in terms of the evidence that they had relied on and giving the merging parties an opportunity to comment on that evidence. So that merger prohibition has actually been quashed by the Competition Appeal Tribunal, and they've sent it back to the CMA to start their phase 2 again, which is happening. So I just think it's important to remember that there are other checks and balances on what the CMA is doing.
There certainly are, but of course there's commercial issues with kind of having to appeal and try to go back in that type of way. It may have killed the deal already at that point. Moving on to antitrust or general competition law enforcement, Veronica, we've been talking mergers solely up to now, but of course a lot of these comments from the government and the CMA also concern general enforcement. What do you see as the key points to note from the recent activity in this area?
Yes, so you're right. We've got a few things going on. First of all, the DMCC, which you referred to at the outset, that gives the CMA new consumer enforcement powers that they'll be able to start exercising from the beginning of April. Now, I think they've actually been quite careful now, and this is probably because of everything that's been going on in the last few weeks and the real focus on proportionality and predictability, to set out the types of conduct that they really will be focusing on in the first few months of that regime. They've also gone out of their way, I think, in the guidance to say that they do understand that it will take companies time to start to comply fully and effectively. And so they will place weight on companies starting that process straight away. So we haven't yet seen anything on the consumer enforcement front, but we expect that to start later this year. The DMCC also gives them power to investigate companies, digital companies, and if they determine that they have strategic market status, they have an additional suite of powers that they're able to use with those companies. Now, they've started, unsurprisingly, perhaps, investigations into Google and Apple, but those investigations can take up to around 9 months. So we're not going to see anything on that front. We'll see some movement on that in October and see what the CMA plans to do there. In terms of its more general enforcement activities, we haven't seen a huge number of headline fines over recent years. So, for example, like other regimes which have those cartel-like powers, we haven't seen a very large number of high penalty cases. Having said that, the CMA does have a very busy workload, and they've been looking at activities in the house building sector. There is often a focus in these cases on impact on consumers. And so we do see a portfolio of cases, and I also think that they're being a little bit more careful about the cases they're taking on. So we have seen more letters to companies saying, we have reason to believe that you may have been infringing competition law. We're not minded to investigate this case on grounds of administrative priority, but we would like you to carry out an internal investigation and let us know how you're going to make sure this doesn't happen again. So I think that does show a rather more thoughtful use of their powers.
Yeah, that's interesting. Looking specifically at the digital markets area, Veronica, as you say, new powers brought in by the DMCC Act, and the CMA currently going through some designation procedures, which presumably will result in the expected decisions. The government at the same time has urged the CMA recently in the draft steer that I mentioned to use these powers flexibly, proportionately, and collaboratively to help encourage investment, notably in the realm of AI. Do you think that's although the government, of course, supports these new powers, do you think there's some kind of an indication there that it wants the CMA to be, if you like, more careful, not to poke the bear across the Atlantic with his various comments, take a similar approach to the mergers type regime where you're maybe looking at less impact on purely global activities? How do you see that new approach, if there is one, kind of being put in practice?
Yeah, so look, I think it's difficult to say, isn't it, until we see where the CMA goes with those investigations. But I do think that was a steer to look at the overall context as well in which the CMA is actually enforcing this new legislation and not look at it on a narrow basis. And I think that's the general theme that we're seeing sitting behind a lot of the other policy suggestions and proposals. But it is quite interesting, isn't it, that there is this focus on investment into AI, and that's obviously been a priority for the Prime Minister as well recently. Yet what we haven't seen in the different proposals that we've seen coming out from the government is any suggestion that they might change the national security and investment regime, which sits alongside merger control. And artificial intelligence is one of the sensitive sectors, which means that any investment by any actor, UK or foreign, because that regime applies to domestic investors as well, any investment of more than 25% in a company active in the UK that does a certain type of AI, that is defined in the legislation, is the subject of a mandatory filing under the NSI regime. So I do wonder whether we might be going there next to try to scope that down a little bit as well, if the government's priority really is further investment into AI in this country.
Yeah, that's an interesting comment. I mean, as you say, there's a bit of a difference there between all this discussion on competition and no discussion of the NSI Act, particularly as the NSI Act, for example, on AI, as you say, basically captures any company that's doing things in the space as defined. And that's a very wide definition indeed. It doesn't necessarily catch what you'd think of as really kind of pure AI companies. So it's a bit odd that it's been kind of left out of the whole analysis.
From your perspective, Veronica, is there a particular facet of development in AI that the CMA is currently focused on? Obviously, with the findings on jurisdiction and Microsoft Inflection and others, you've seen kind of a step away from potentially the flow of labor with respect to AI, but is there another facet that you think is a particular focus?
I can't see, certainly from where I'm sitting, any particular area of focus. I think there is a concern that they want to make sure that they have understood all of the different aspects. I think that goes back to previous cases where they might perhaps have let a transaction through, and then it's only become clear in later years actually what a tipping point that was in terms of what that meant for the technology. But from where I'm standing, I don't see any particular area of focus when it comes to AI.
So, Veronica, before we move on to the final part of our discussion here, could you just give us what you think are the key practical takeaways for lawyers and companies, particularly those based outside the UK, in relation to the current and forward-looking UK merger control and competition enforcement landscape? Are there some key things that people should be looking out for?
Yeah. So look, first of all, when it comes to doing transactions and investments, I think even though we do have these comments about this might be a good time to get that trickier deal through, I think it's still really important to just go through the process, see whether you think that the CMA might have jurisdiction over your transaction, and then think very carefully about strategy. Is it best? Well, first of all, is it best to actually put a notification in, because there really could be some competition issues and you're likely to get the CMA looking at it anyway. So better to be proactive. And here the CMA is saying that it's going to start dealing with pre-notification, which in some previous cases has taken a very long time, much more quickly. But if you're looking at a transaction or an investment which really shouldn't have an impact on competition, thinking about the strategy of whether you go in with a briefing paper, and I've seen the CMA make a lot of sensible decisions in recent months, years, with the briefing paper and say, we have no further questions, and not come back with any further questions. Or as we chatted about before, there will be some investments where it isn't worth, and the best strategy is not to tell the CMA, accepting, however, that you might still get asked those questions. And then when it comes to compliance more generally, I think it's just really important to make sure, especially in investments and portfolio investments, that portfolio companies are complying with the key competition rules. The other thing that we haven't talked about so far is the CMA does seem, or at least did in recent months, seem to have a bit more of a focus on competition restrictions in labour, in employment contracts, no poach. I know that's been quite topical around the world as well. But that was an area that they were looking at quite closely a few months ago, made a few general announcements about. So just making sure that on the enforcement front, there are no easy wins for the CMA is always a good idea.
Thank you. And I guess on the substance, before we move on to our final segment, similar to the EU, I think we're going to probably be seeing more arguments around efficiencies and trying to justify deals on various grounds under the overall efficiencies bucket.
Yeah. And I think so Vodafone, the 3, which we talked about already, was a really interesting case in that respect. Lots of efficiencies, arguments being tested to a very detailed extent by the CMA before they were accepted. And of course, we've tried to run efficiencies arguments for many years now. But again, that is an area, if you're able to justify your efficiencies arguments and relate them specifically to the transaction, I think that could well be a very interesting area going forward.
Absolutely. Veronica, we like to finish off this interesting discussion with a question for you, a personal question. So firstly, could you please tell us something interesting or unusual about yourself that we wouldn't know just from working with you?
So something interesting is that when I get some spare time, one thing I do like to do from time to time is really push myself physically, which feels a bit different to the day job. And so a few years ago, I managed to get up to Everest Base Camp, which was a source of great pride to me. Really enjoyed doing that. Had to get myself a bit fitter before I went, but something that I really enjoyed doing.
That's amazing. What altitude is that?
So actually, I climbed to a little mountain that's just above base camp. So it was 5,600 meters.
Wow.
Bit harder to breathe than just sitting above Liverpool Street Station in London.
That's incredible. We also like to do a segment called Our Curious Hat.
And now it's time for the Curious Hat.
And the idea here is, Veronica, you'll pick a number between 1 and 20, and it'll be a random question to help our audience get to know you a little bit better outside of antitrust law.
Okay, 12.
All right. What book are you reading right now, and what do you think of it?
Clara and the Sun is the book that I'm reading right now, and that's very topical because that's about having an AI friend, and I'm really enjoying it because it's making me think about how AI could actually start to impact our lives. And so it's a book about having a friend who is an AI friend, and how they go about day-to-day tasks, and also what sort of feelings they have. Their feelings are quite basic at the moment.
Wow, a real commentary on our potential future, very topical. So thank you for sharing.
Thank you, Veronica. That was a great discussion, and thank you, everybody, for listening to this episode of Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.